A YouTube rapper known as Slimmy has pleaded guilty to 2 counts of dealing with proceeds of crime after he went on a massive spending spree after unexpectedly receiving £428,000 into his account. He told police that he just woke up and saw the money in his account and then went on a shopping spree. But this video is a warning to you that this is not a case of finders keepers. So welcome back, but if you're new to me, I am a barrister who helps you understand law. And this is a rather very interesting case, but also comes along with a warning. So this story follows lots of other stories and videos that I've found on social media where people have been given the wrong food at a drive-through. Not a patch on the £428,000 that this singer/rapper found in his account one morning, but both the same principle. You see, if you receive something that isn't yours, and you know it isn't yours, and you know where it came from, and you can with some reasonable diligence get it back to the person or the corporation that owns it, you should do so, because you don't own that money or food or whatever it might be. So even in a simple case of going through a drive-through, if you are given the wrong food, some of the videos lately that I've seen say, well, that's not my fault, you gave me the wrong food, so I've eaten it. In some of these videos, the assistants or even the manager has been asking for the return of the food, or if they've eaten it, the price of the food, because they shouldn't have eaten the food. And that's absolutely right, because if you know that something doesn't belong to you, you shouldn't be keeping it. The only alternative is if there is absolutely no way that you could find out who owned this thing, money, whatever it might be, because if you just, let's say, find something in the street, a £10 note, and there's no other identifying features on it, and no way that you can identify who it belongs to, then that's usually fine. You can usually keep it. However, contrast that with a situation where you find a wallet in the street and there's conveniently an ID in there, might be a driving license or something else, or even a bank card with the name on it. If the bank card has the name on it, let's say it were NatWest or HSBC, you could go to HSBC or NatWest and say, I found this wallet, this is the name on it, can you please try and identify it to get it back to its rightful owner? If that's the case, with minimal diligence, you could do that and it could get back to its original owner. If you were to keep the thing, the money, the wallet, the card, whatever it might be, that would amount to theft, because each of the elements of theft don't have to occur at the same time. The appropriation of property could become dishonest at a later point if you've dishonestly decided to keep the thing, which you know doesn't belong to you. And if you intend to permanently deprive the other person of it, then eventually you can make out all of these elements of theft and keep the money. Just as in this case reported by The Sun by this YouTube rapper known as Slimmy, who went on a shopping spree and spent £341,000 in one gold bullion in just one store. This was just before spending another £57,000 in another shop where he bought expensive coins, reportedly also buying clothes and makeup and various other sorts of things. He told police after reportedly initially denying it that he just woke up and saw the money, but now has admitted to 2 counts of dealing with proceeds of crime at the local court in Sydney. He's been given very strict bail conditions not to go near any international airport and a strict curfew of 10 PM to 7 AM. So let this be a warning to you. If you thought that it was going to be something perfectly innocent to have finders keepers for whatever it is that you've found, think twice and think very carefully, because if it's possible to get this back to the original owner and you decide to keep it, then that can amount to something that is dishonest. That's particularly prevalent now that the test for dishonesty has pretty much been turned on its head with the gauche versus Genting casinos distinction. It used to be both a subjective and an objective test. In other words, what would an ordinary, reasonable, honest person think and what would the defendant think? Now, the courts don't tend to rely on what the defendant thought. The test now is pretty much if an ordinary, reasonable and honest person believed that this activity was dishonest, then it's dishonest. If you're interested in criminal trivia, there are lots of interesting books on Amazon. I will link 1 or 2 of them in the description below. Go and check those out. I will also link one of the revision books for any of you that are interested in the way criminal law works. I will link some of those in the description as well. These are what bar students might typically use for revision for the criminal litigation exam on the bar course, which together with the civil litigation are notoriously difficult. So I hope you found that interesting. I hope you took the warning, and please do remember to like the video and subscribe, and as always, thank you for watching.